Buenos días.
Good morning,
Muchas gracias
and thank you
la sesión,
for attending
cuarta sesión
this fourth meeting of the Committee to Support Implementation and Compliance of the Escazú Agreement.
para nosotros es
For
un
us,
placer
it is a
compartir
pleasure
el día de
to
hoy
share the day
con más detalle
with further details
web del comité y la
the
plataforma
committee website and the online platform
se presentarán las comunicaciones.
through which communications shall be sent.
Presentación
We will also have a detailed presentation of the modalities of work,
contestar las dudas que surjan
answering the queries that may come up in that regard,
después
and
del
then
receso.
in the afternoon, after the lunch break, we will have
Grupos
group
para
work
escuchar
to
los
hear
insumos
your
sobre
inputs
ciertos
on
temas
certain topics
que los preocupan.
of concern.
Entonces, vamos
And
a
so,
comenzar con el
we
primer
will
punto,
begin with the first item of the agenda, which is the presentation of our website
y
of the committee and the communications platform, for which I will recognize David Barrio from the ECLAC Secretariat.
Muchas gracias, Presidenta. Muy buenos días.
Thank you, Chair, and good morning, everyone. Before getting into my topic, I would like to congratulate you because yesterday we concluded a very successful conference of the parties with 6 decisions, including the action plan on the defenders of human rights in environmental matters, which is very good for our activities over the next 6 years. Everything contributes to implementing this Escazú agreement, and of course, at the committee, we will have to support those efforts to ensure they become reality. Today, in this fourth meeting of the Committee to Support Implementation and Compliance, we're very proud to present a web page and platform, which have also been the result of the work of not necessarily myself, but the entire team of the library and the web services, and many colleagues who are not with us now because they are still working, improving it further to make it more effective. And the substantive team of the Division of Sustainable Development in collaboration with the committee that we have also been putting together to ensure that we have an output that is useful and that reflects the needs and realities of the region, keeping to the rules and realities of the committee work as adopted by the last meeting on Monday. As you enter the room, there are 2 screens on the right as you enter, and there the website is available for you. These are tactile screens, so please be careful because they are sensitive and to touch, but you may navigate the website and in a practical terms this new product. And the website seeks to comply with 5 points. They say they're easy, but they're not easy to implement. The first is provide access. We know that it's a website, yes, but it needs to meet certain access standards. Not everyone has the same capacity to navigate or access this sort of platform, and so therefore it does meet with UN standards for these screens and is also optimized for mobile phones and different engines and connections. And the other element that I would like to highlight before seeing the web this page on screen is security. this is something that has been very important in terms of design because we're working with people's data. One of the functions of the web page is that it gives you access to a form and where you can communicate by the rules. When the COP meeting ended yesterday, that marked the beginning of the period when the committee will receive communications. The form was enabled as of last night, and so there's personal data, yes, and there could be data that's more sensitive of different types of groups, documents that are private, and so on, that are just for the knowledge of the committee. And so I say not only the way in which they're sent, but the way that they're saved and processed requires of a high degree of security protocols. And this has been new to ECLAC as well, because at ECLAC, I would dare say that all the documents that we work with are public. And obviously, HR has the personal data of the employees. But aside from that, there is not much further complexity in terms of the website. But yes, here we are also considering a reality in the region, and that the agreement does take responsibility for the defenders of human rights are at risk and are threatened, and they could go appeal to the committee. And so any security failure that may expose them could have very significant impacts. And so the security is our ally, but this has also limited us in terms of some of the things that we could do on the platform. And the third point that I would like to highlight is the automation. And why am I telling you all this? Well, automation facilitates not only the work of the Secretariat, but also the committee and you. The possibility that all stages, especially communications, have some degree of element that pulls through automatically and that meets with a more or less technical flow and that is independent and that provides ease of mind not only to the members of the public but all the stakeholders that are the subject of the communication or that file a communication for them or other states party. The fourth element is traceability. This same automation allows learning for the authors and the parties, the status, what aspects have been met, what not, in real time. And this will also be valid in the public side of the website and the platform that we're going to see later on. And that is what we call the repository of the communications. And there you have whatever the committee determines is public. The number of cases are appointed, the date when it was filed, the state party involved. All of this coming from the public, but there are other aspects that do require of a certain verification, and also there's the will of the author that may request their data be safeguarded. But this allows traceability. That transparency, nevertheless, allows meeting the mandate of the Escazú agreement. And the other aspect is being amiable. Everything done with the web is balancing a balance of all these things, so that navigating be easy. And so the access to the website is the acronym in Spanish, CAAC. So I invite you to visit the website because this is continuous work, innovative for ECLAC. It is something that is at the forefront, even internationally, from where we have tried to pick up on the best practices from a body similar to this one, Inter-American Commission or other forum, to be able to use the best and improve it. But there's always a margin to include aspects that were not originally considered. And so this depends on the use given and the comments that you may make. So now getting into, I know we're running a bit short of time because we need to see the modality, but I would like us to see very quickly the website. This is a site that goes beyond the communications platform. I focused on the communication because it is an area where we've paid a lot of attention. But the working side also gives us a very clear mandate. And perhaps the data and, well, everything that I've said so far. But let me tell you how the website is structured. You're going to obtain all the information and committee data as to who the members are, when they were elected, the periods, functions, and even a breakdown of each one of their responsibilities. And this is the drop-down menu. It is about the sessions, meetings, communications, other resources, infographs, rules, and progressively we will include other elements to facilitate the use and the implementation of the platform. And then you have news. We've also highlighted here the communications on the first page, the data on the operations of the committee, which is one of the main aspects contained in the website. And it's an entry point to the committee. So here, in turn, if you click on the presentation, it does not take you directly to the form, but rather it goes to an intermediate page that tells you what the form is about. And because the form is something that you cannot complete quickly, no, you need to dedicate time to it. You need to have the support documents, and for this to be time well employed, it clearly explains the stages asked for, the documents that you must have, and also there's an explanation of some of the rules that are applicable. For example, the state's party, what is considered to be a state party, and some of the things that also affect the presentation. For example, temporary ones, because it's not just a state party. There, at least a year should have gone by since the state has became party too, to be able to access the communication. All of that is there to facilitate user. And then this is only available for the authors and state parties. And here you have a personalized access with the codes conveyed when the communication is submitted, and focal points will have also direct access to the platform. And this will require training that we're still preparing for everyone to be familiar with this. But it will facilitate access to all information, and through the link you can in turn send comments on each case that may concern you. And as you recall, all state parties can be participant to other states party, and everything in the same same file, which simplifies the treatment and processing by the committee. And then lastly, the communications repository. This is the public side. I did not mention it before, but what we're seeing here is the 5% of what has been the work of the technicians and the substantive work.
Most of the platform is for the committee's work. It is part of management of how the information is managed. And in the repository, we will place all those elements that are of public knowledge as the committee determines them. Here we have a brief video, if you will, on how this is completed. This is real time. The web colleagues prepared the simulation, the demo. It's not on real time. It shows the documents and each of the things that are required, those that are subject to the state parties, the documents themselves, support, the different aspects that are being presented to the committee, etc. The idea is to guarantee security, and so that when you fill out the form, you may rest assured that we are protecting our data. We are using the best we have at our disposal. Of course, nothing is infallible, but everything that we were able to obtain is in this form. The idea is for it to be secure. And that way, it allows for trust with the committee. So Patricia would like to invite you to make use of the website and your comments and questions. We'd like to thank you for the space. Could you also repeat the address again, please? It's CACC. Sorry, CAAC. CAAC.eclac.org.
Muchas gracias a las personas que se han unido a esta sesión.
Thank you to all those of you who have joined this session.
Si quieren sentarse en los puestos,
You can
perfecto.
take your places.
Pensaba que en la sesión del día de hoy, el primer punto era precisamente conocer esta página web del comité.
The website of the committee includes a platform for presentation on communications. This is new for all of us, for the states, for the public in general. And therefore, the touch screens that are outside are for you to approach during coffee. You can use them and see how they work and how you use the platform. As David said, we're going to have training for the adequate use of the platform. Here we need the support of all organizations and of the member states for the use, and so that this platform can join us in the different functions of the committee. So these were adopted last Monday. These have been handed over in printed fashion. You have the document in front of you. I'd like to offer the floor to Guillermo Acuña. Thank you, Madam Chair. Thank you to all for being present here in this activity that we believe is extremely important. Has to do with the presentation, the first public presentation of the working modalities of the Committee to Support Implementation and Compliance of the Escazú Agreement. As you know, this was prepared by the committee itself. It is on the content of the different modalities. I'm not sure if you've had the opportunity to familiarize yourself with them. We would like to invite you to know the work modalities because it has the intention to facilitate compliance within in the working sessions of the committee. It has its purpose and nature, structure and composition, sessions and organization of the work, sessions for information and support to the conference of the parties, advice and support to the parties, communications, which is the key element. It's part of the committee's work, which the public and the member states will be presenting as requests to the committee, so they may offer their opinion, and other positions that have to do with the operation of the committee. Here's a structure. So there we have the mandate of the working modalities. Someone I greatly appreciate and that I had the pleasure of working with recently is form over function. And this means that it's important to have clarity. We need to know how the committee is going to work. It's also important to know the legal base or foundation of this working modalities. Article 18 establishes the support committee with numbers 1 and 2, and the first conference of the parties adopted, and that was the first decision actually of the conference of the parties 1, adopted the composition rules and operation of the committee for support in compliance of the agreement. It also states in Roman numeral 1.2 that the committee will elaborate its work modalities in terms of, in accordance with the rules of composition and operation of the committee, which will guarantee the significant participation of the public of the countries in Annex 1 of the agreement and with the different modalities. And it makes reference to the participation of the public of the countries pertaining to Annex 1 of the Escazú agreement. The objective and its nature are the ones that we see in the committee. Rules of the COP decisions is established rules of composition and operation, and they seek to organize in a practical manner what the public and the committee are going to do in terms of work. And another objective is to articulate the details of its structure and operation or functions, which we will look at now. These working modalities were adopted, as Ms. Madrigal said, last Monday. It was the mandate that we had that was to be adopted by the committee as a way of obtaining our independence, always following the rules from the beginning and with independence that is hopefully that committees should have in their work. I'd like to refer to the structure of the committee which we find in the working modalities. The committee is made up of 7 members elected by the Conference of the Parties last year in April 2023 in Buenos Aires. And after a long participative process, I won't delve into the details. We made mention to this twice, to the way in which these elections came about, the 7 members of the committee that I am honored to be a part of. The practical structure established a chair the obligations, the quorum limits in terms of how the work is carried out, the representation of the committee and the different functions, and also on how the work is organized and guided. There's 2 vice chairs, also as part of the work modalities. Carol Excel Stephens and the second vice chair, they have the same responsibilities and rank, Andres Nahuet. The rules and the working modalities established at the distribution of these positions, both the chair and vice chairs, as well as the subcommittees, will take into account the geographic distribution, equitable with gender parity, and if possible, with rotation. The chair may also establish subcommittees and other groups, and we already established the first subcommittee. It is called the Admissibility and Communications Subcommittee. It is made up of Felix Wynn, our colleague Rita Joseph Olivetti, and myself. We are the 3 members of this first working subcommittee, which was formed last Monday. But the chair is also empowered to prepare or form spokesmanships. And on this conversation on the defenders of human rights, the chair established a rapporteur on defenders of the environment, and that responsibility lies with Carol Excel Stephens. We have a lot to cover, so I apologize if I'm going too fast. We also have ordinary sessions and extraordinary sessions. There are other groups of sessions that are the informal groups. They are not mentioned. We have a huge amount from the work that we've been carrying out since August last year, April last year. We've had a huge amount of sessions, informal working sessions, in order to organize the ordinary sessions. Ordinary sessions set the working modalities. These will be carried out at least 3 times a year, at least 1 in person. And these are open to the public, to the member states, and to all those who are interested in participating. They are announced through the website of the Escazú Agreement and through the public regional mechanism. The ordinary sessions can be open and they can also be closed. The closed sessions have special rules, and they decide the way in which the results of these sessions will be made public eventually. Extraordinary sessions, as their name states, are summoned by the chair after consulting other officials that make up the committee, and these aim to treat urgent matters that must be considered due to their urgency before the next conference of the parties. These sessions, extraordinary sessions, will be summoned by the Secretariat once the committee decides to carry them out, and a date and place will be set, and they will actually be, when possible, virtual.
Should it be necessary, the character is to be face to face.
El proceso de toma de decisiones también tiene que ver con la forma.
It also is related to a very long and discussed matter where we were really debating on the working modalities. You know that this was an open participatory process. The state parties sent information. We had discussions. We met the representatives of the public, the agencies and programs of the United Nations, the Inter-American system, sent comments, and all this helped to understand and improve, of course, all together with a presentation of the ARHUS agreement with tremendous experience in support committees and the compliance committee of the ARHUS. That was helpful as a supply in the creation of these working modalities. The decision, the principles, the main principle in the agreement is to adopt decisions by consensus. If this consensus does not occur, the decisions will be made from the votes of 2/3 of the participants of the committee, meaning that with 4 participants of the committee, the decision can be made as a majority. The decisions can be done in person, virtually, or electronically. This was also tremendously discussed, but we believe that to be able to stop with the bureaucracy and make this committee more dynamic was to make these decisions on an electronic fashion. This will be always detailed and will be very explicit in terms of its content. And this is what is motivating us. Something else, additionally, the discussion was the working languages. The agreement establishes that it's Spanish and English, the working languages, and this establishes a limit to how the sessions have to be carried out, either ordinary meetings or extraordinary. Should there be either parties or persons participating in the committee and using a different language, they have to provide the translation, the interpretation of such intervention so the committee can work with the languages that have been established. Two important points expressed there are the agenda and the minutes. As you know, this is something that is quite natural for all the meetings that we have held throughout the Escazú process, and the provisional agenda is created by the Secretariat and subject to the or presented to the committee that will either adopt it and announce it whenever there is an opportunity to hold the ordinary and extraordinary meetings. And the minutes is also an important element. The minutes are the summary of what was dealt with in the committee and all the working activities, either ordinary or extraordinary, where the formal meetings do not hold minutes, don't present any minutes. And the principle guiding the minutes is the advertising of the actions, that the results of such sessions should be public, except that the committee will define that the content of those minutes will not become public. That decision has to be supported specifically or especially when presenting the content of those minutes can eventually expose, for example, a defender of the human rights or not be the proper element. All this is detailed in the working modalities, and it is important that you are able to review it. And now I we'll go to the last part of the presentation, and this is functions, information, and support to the Conference of the Parties and the advisory to the parties. These are two very important activities that are established within the working modalities following the rules of composition and functioning, and it is related to the creation of reports. The committee has three types of reports: activity reports, systemic reports, and the reports on anything related to application and compliance. It can be done through documents or maybe because the parties requested the supplies for the creation of these reports. The committee can request them to the state parties or representatives of the public and organizations and experts that can cooperate in the creation of these reports as well. They will have a final draft that will be made available to the public once the report is approved. But there's also another important function which is related to the advisory to the parties, and this is a consultation of the interpretation of the agreement, something that is truly important, and it has been expressed throughout the meetings and presentations that we held from Monday till yesterday in talking about the agreement. And this is something that provides the committee the possibility to make certain anything that the agreement reads or it refers to in its content. It is specific in what the agreement expresses in a determined or specific topic. The committee can also present general observations on any related to compliance of the agreement. But there is another important element that is related to consultation and periodic dialogue with the parties, which was also yesterday decided upon. Chile to find that they could be the first country to be visited and consulted. And this consultation and dialogue with the parties is important as it allows the committee to go to the different sites and share experiences and talk about the application and compliance. And the committee will issue observations on those visits and create a report as well. But this slide also talks about open dialogue with the parties and the public. In number 18.5 of the working modalities, for us becomes a central aspect, as this is space for participation as an open dialogue with the state parties and the public. And they have to be dealt with or defined in the agenda, meaning that it cannot be done per se, but it has to be defined in an agenda that is circulated for approval by the different members of the committee, and the secretariat will publish it. My apologies for doing this so fast, but I am quite overcome by all these activities, but this is a very brief summary to present what we have been doing so far in the working modalities, and I will offer the floor to the chair lady so that the colleagues can continue with the rest of the presentations. Thank you very much. Thank you, Guillermo. I want to thank those that have been coming in the room and also are participating virtually. And I want to thank you all for participating in this fourth session of the Committee to Support Implementation and Compliance of the Escazú Agreement. In the first part, we had the platform we saw the web page and including the communications web page, and we were letting you know that outside of the room we have some screens to interact and learn how to use the platform that we are launching today in different areas, topics related to the committee, not only the presentation on communications. This first part of the presentation provided by our colleague Guillermo Acuña on the working modalities, I would like to know if there are any questions or concerns that you might have in terms of the structure, nature, functions, or decision-making process on behalf of the committee. Good morning. Good morning, committee and participating public. I have a question. I was collaborating with the consultation process in the design of the implementation plan for Chile, and we always miss the presence of the committee, believing that the plan and the roadmap offers a national governance that, depending on the country, of course, will have a specific structure adopted by the countries. And given this and the map of key agents, I believe that it was interesting for the committee to participate in those governance. Maybe I'm mistaken, but we are missing that link so that the plans that require some external monitoring, and we understand that even though governance is a national element, maybe there could be participation in those areas. Thank you. We will take 2 or 3 questions. Olympia? I believe that in the open dialogues with the parties and the public is what is really having the public feel concerned. We can imagine the committee going around Latin America and the Caribbean and assuring that there are very complicated situations around, and that I would like everybody to come see what is happening in my territory. That would be a very specific request. Therefore, in understanding this reality of how it would be working, it would be very useful to know how it works. Anybody else with questions, comments? On the implementation plans, as you are expressing, these are the plans that the state party creates for the compliance of the Escazú agreement. Therefore, this is part of the decision-making process that is sovereign for each of the countries. Nonetheless, from the committee, we have really been taking into account the different processes in creating the plans, and we will be following everything very precisely. I think we should provide space and time for the different countries to move forward in their compliance. However, they believe it is the best fashion. Maybe the state will include that topic in and dialogue with the committee. As an example, Chile could perfectly be defining that is a topic they would like to tackle in their dialogue with them, in the discussion with them. But I believe that we should provide them some time for application and compliance, and eventually, further on, this could be part of a systematic report in trying to obtain lessons learned of all the processes that are occurring in the region.
These are possibilities, really, but it's what could happen. Now, as to the concern of Bolivia on how these open dialogues are to be. I think that the best thing in the process is that we are building, and there are general rules that, and what is constantly repeated are the principles and the values behind Escazú. There isn't a rigid, strict regulation on how this is to be developed. The idea is to build this together with the public or the parties. The methodology has to be developed. We have to think about the agenda. And as a result of these dialogues, we will have a definition. And that would be the outcome of dialogues. I can tell you, and by the way, we will have an afternoon session on this. And we are certainly open to receive topics that will guide this dialogue from public and state parties. I propose that we take a break. And here we have to manage the time. We have to be punctual to take 15 minutes for the coffee break and also to take a look at the screens that are outside. Afterwards, at 11:15, we will return to the next part of our working modality, and that has to do with the establishment of communication to the committee. Thank you.
Bueno, vamos a continuar con la sesión.
We're going to resume session.
Para revisar el tema sobre las comunicaciones.
So, in order to take a look at the communications, there are some elements for its admissibility. We're going to offer the floor to Andres Napoli. Good morning. Thank you for your presence. We're now going to analyze the more dense part of these modalities because we need to look at how communications are going to be dealt with. All communications that arrive at the committee. I'd like to thank the Secretariat for all their work with collaboration of all the states that have contributed with their comments, and special thanks to our chair. Let's talk about communications. Here's some infographics. That's quite positive. We're going to have a flow of information. And of course, we need to follow the numbers.
Así que, si me acompañan los que tengan.
Those of you who have the printed document, we're going to look at number 6, more or less. So the first thing, 6.1, is that who can present a communication or file a communication. These can be filed by a party with respect to itself, a party with respect to another party, or a member of the public. That's the way the communications must be filed.
Modalidades han adaptado. ¿Qué se puede pedir en una comunicación?
What can we request in these communications? And here we go to 6.2. Communication may request support for compliance or alleged non-compliance of one or more provisions of the agreement. So bearing this in mind, let's take a look at how we would file. I'm not going to look at the procedures much in detail. We are just becoming acquainted with this. When the committee receives a communication, and these communications are analyzed preliminarily with a series of requirements established in the rules, and they can either be declared admissible or dismissed. If it is admissible, that is number 2 that we have there, the procedure establishes that a preliminary analysis will take place. So in the first place, we look at form, who has presented the communication, how it has been filed. This has a lot to do with the form that we find in the website. And then the communication must be presented following a procedure. It has to be done in writing. And we then take a look and establish which are the articles that would be in compliance, what interventions would be sent to the committee. And as Guillermo mentioned, and this brought about a lot of debate, are the languages. We have official languages. These are entered in Spanish. There's an effort made to work with Portuguese, but the different languages will provide for a lot of work, and in principle, the translations must be carried out by those making or filing the communication. And we will be working with the committee to enable this. So that people in vulnerable situations may be able to exercise their right. So I'd like to invite you to read number 9 and 10 to take a look at what requirements there are: name, domicile, address, nationality, so that we may understand whether the state is a member of the agreement. In the case of the representatives of a state party, the facts on which the communication is based and the information supporting it, the provisions in respect of which support is sought or non-compliance is alleged, and any other information that could be useful to the committee. And a key element is that it doesn't really require legal representation. And the committee can undertake to protect the identity and privacy of those who request it. The committee shall not receive communications that, and here we have a series of aspects. We have Rule 5.5 of the composition of the committee and the modalities in 613, where we see a series of things that need to be respected. I don't want to forget the modalities, but I'm going to summarize. When communications concern a state that is not party to the agreement, if we want to communicate on a party that is not part of the agreement, it is not admissible. Also, when they are not filing in another before another body or has not been solved by another body. In that case, it is not admissible due to the rules of composition of the committee. We also shall not receive those that are filed less than 1 year after the entry into force of the agreement for the state party. It's important. They need to be in the provided format. If they're not in the correct format, we will still make all efforts to try to adapt the presentation or the filing and anonymous filings. So these will also not be admitted. Another element to take into account is number 625. It's important to describe, as we see with the elements that allege non-compliance, what are the things that are established in the state that lead to this communication or to alleging non-compliance. I'd like to go back to the fact that this is a non-punitive, non-judiciary committee. So the analysis of this paperwork is different than how it would be in other committees. So we can take into account the exchanges, written exchanges between the author of the communication and the state party, the administrative, judicial, and extrajudicial actions that have been carried out, the mechanisms that we have at hand to resolve alternative dispute resolution mechanisms, the alleged absence or domestic legislation protecting the right in question, or that did not allow for that, or if there's a justified delay, or any other relevant element that can be considered in this sense. I just want to clarify that this committee will not require the internal path, but we aim to support the compliance of the agreement. And for that, we do not require these circumstances, so we need to be very clear when we file a claim or a communication. So we established the admissibility of the case, and then a series of observations to the parties are made. That is what we call, we notify the parties so that they can, and we need to get used to the language that we find here. Attention of the party is made, and that means that the allegation of non-compliance or the communication is taken to the state party so that they may provide details justifying the request. So it allows for the state party to reply, and then the committee would have the necessary input. Something I mentioned that I did not mention, but is interesting, is that we can also have public hearings to verify admissibility, even for the fund. These public hearings need to be requested by the party making or filing the communication, and the committee may decide whether it will be admissible or not, and decide what else needs to be clarified at the moment of the presentation of the admissibility or the filing of the communication for admissibility. Then in the observations of the party, we would be talking about number 4. Number 4, we can do this with or without a hearing, and we would call for a hearing, but the modality of functioning establishes a series of minimum requirements, and I believe this is a good foundation for all of us to take into account. So how do we examine these communications? The communications are examined in the order that they are deemed admissible. There's no other specific order unless we are thinking about a rapid response mechanism for risk situations. We will explain that in more detail, and those are a separate item in the process. In that case, the committee may take a more recent admissibility and put it to the attention of the committee to offer a quick response. As I mentioned, both parties can request a public hearing, and after this procedure, we go to number 5, which is establishing the final conclusions or preliminary conclusions, and these will allow us to, and here I'd like to invite you to look at number 55, which clearly says, after analysis and deliberation on a communication, the committee shall adopt its preliminary observations, which may include specific recommendations on compliance or non-compliance. Preliminary observations shall be transmitted to the state party concerned and to the author of the communication after a period of 2 months, which shall be granted for written comments. After such period has elapsed, the committee shall adopt its final observations. So this is not a legal or punitive committee, but the rules of due process are fully protected. So whoever files a communication may rest assured that their communication will be protected and kept confidential, and there will be an analysis that will aim to contribute to better and more effective compliance of the CUP. The functions of the committee don't end there, because after that we have monitoring, and that is number 7, which is towards the end, and that monitoring and reporting establish a series of elements to be taken into account, which is following these recommendations, receiving reports from the committee biannually, and of course the person making or filing the communication will be offered this information as well.
I am ending here this very fast description. It is very dense as well, but it is the procedure that is established, and you can thus see how the committee will be working for each of the communications. Thank you.
Muchas gracias, Andrés,
Thank you, Andres.
por la explicación.
Thank you for this explanation.
Creo que es importante
I believe it is important to express
modalidades de trabajo,
that the working modalities
las reglas de composición
of the committee are framed in the rules of composition and functioning of the committee. And these rules, adopted in Decision 1/3 in 2022,
deben ser cumplidas
have to be fulfilled as they are by the committee.
establecen una serie de
And
plazos
they define a number of deadlines as
proceso
this process
estamos viendo
that we are seeing here is a process that needs
previa a
previous preparation prior to the presentation of the communication. Even though there's a virtual platform, there's a need to prepare this communication, as very well expressed by Andres. And this is what provides good identification for a non-compliance, which is the part of the Escazú agreement that is the non-compliance. How can I prove it? But additionally,
en las reglas estoy buscando
in the rules,
plazos cada
I am looking for the deadline. Every time there is some sort of communication,
debido proceso la participación
due process has to allow the state party and the interested party, they are able to participate, meaning that the deadlines of these processes are not as short as we would like.
puedes repetir un poquito de eso para entender, digamos, qué estamos hablando. Ya. Mientras Andrés nos ubica más o menos
While
los espacios
Andres is
cada una de
allowing us to understand the timing process for each of the stages, I would like to know if there are any questions, comments, and same as in the previous session, we will take 3 at a time. Gustavo?
Gracias, gracias Patricia. Espero que se escucha ahora. Sí. Gracias Patricia, buenos días a todas y a todos y gracias por
Unfortunately, the booth has no sound. Maybe the microphone is off?
de manera conjunta. ¿No se escucha?
danos un segundito, es la traducción.
Just a second, because we cannot hear the enter.
Adelante. Tal vez comenzar a ver si ya, ahora sí.
¿Escucha ahora la traducción?
No, no. Es que las traductoras
¿Escucha ahora?
escuchan el micrófono.
Interpreters cannot hear this microphone. Maybe the microphone is off. Maybe you can go to one of the microphones on the tables and you will be able to talk from there.
Gracias.
Thank you, Patricia, for this time and opportunity and be able to comment with you 3 topics. One is I would like to ask whether these observations, the ones that you are mentioning on number 55, where there is a 2-month period of time, those observations will finally be taken into consideration for the final conclusions, or it is just a deadline, receive the observations, and conclusions are completely separate. I am asking this as there is a similar mechanism in TRMEC between Canada, Mexico, and the US, where there are cases presented related to governments in the non-application of the environmental rules. And at some point, it is established that the states that are mentioned have the opportunity to present observations on the specificity of the content, what is the specific document, and it expresses that the Secretariat will incorporate what is necessary that or needed to be incorporated in that document. Therefore, I would like to again repeat and ask whether these observations that the party and whoever presented the communication, if these will help to reinforce the conclusions presented. The second question I have is related to something I was able to hear, and if I am mistaken, please, apologies, but I understood that there's a time, a moment in which we cannot separate this case in different fora, if I understood correctly, meaning you cannot have it here and then maybe communicating it in a different form. And if this is the case, I would like to ask which is the fora that we're talking about. And again, apologies because I'm ignorant here, but was there any activity with the CHEMEC? Because the mechanism is quite similar. There are many experiences with more than 80 cases that have been presented there due to a non-effective application of the environmental ruling, and many of the lessons learned in a number of years of the NAFTA and now the TMEC maybe can be useful in learning what did not work, which were the barriers, the obstacles that existed, and be able to bring them in here and implement them so that the procedure works properly here. Thank you very much. Thank you, Gustavo. Anybody else have any questions or comments? Good morning. From the presentation, I want to confirm certain elements. The first one is the inadmissibility and that the communication is anonymous. We were working outside with the screens, and one of the fields allowed to express that the communication was anonymous, but I do not know if that means that somebody might, maybe a leader that would like to present a communication, maybe say that that is a possibility and that becomes inadmissible. So I'm not sure if the form can generate a confusion of what we're understanding here, and I would like to confirm whether I am correct or not. And then from Mr. Napoli's presentation, I understood that the possibility of having hearings throughout the procedure is whether is the requester or the state party that is going through this communication, the one that is requiring it. So we need to understand that the committee will not ever request a hearing. It has to be requested by the two parties of the communication, and I would like you to confirm this, please. We're trying to understand it. And the third question, my apologies for being so long. If whether the hearings could at some point be directly on field, or would this be in person here, or maybe virtually, or whether it has been taken into consideration that that could be done in the territories on behalf of the committee. And my last question is whether there will be a pilot stage or testing stage. I understand that given the due process, the state party will have a possibility of receiving this communication and the different proofs that were required by the requester, and the state will provide information of the facts um, and the burden of proof. But if whether there will be a possibility to request these proofs by the committee, if the response is positive, I would like to know how you have been thinking about this when reviewing other similar committees in these international treaties, how that could be funded, because we have issues of funding that we have been talking about for a number of days, and I would like to know how it is done in different instances. Thank you very much. Thank you. Good morning. My name is Gonzalo Aguilar. I am a professor of constitutional right of the Constitutional Center of University of Talca in Chile. I would like to express certain things that come from reading this on the working modalities. One first aspect that I was talking about this during the coffee break with Guillermo Acuña, and later on was clarified by David Barrios, is related to the interpretation that the support committee has, expressing here that the interpretation request can be presented by a state party or a representative of the public. And then a question arises is, can it be anybody from the public, or is it just restricted to the public, the representative of the public? And Guillermo explained that there is a representative of the public with a content with so many inhabitants that becomes a restriction. But David Barrios also expressed that this comes from the rules, but I wanted to express it as well. My second point is translation, especially in a continent where there are, and I am thinking about indigenous people, as the working languages are Spanish and English. I believe that having a translation of what is to be expressed by these people that live in under situations of poverty or difficulties could also be a restriction to access. That is a thought that I have in mind. Maybe we would have to look for a way of not forcing them or placing this burden, if you wish, on the weakest. And a second thought was already expressed here by the gentleman that had the floor earlier. It is the inadmissibility rules. It also stands out to me whether it would be possible to elaborate on these inadmissibility rules whenever this was presented to another organization, either regional or other, this would be inadmissible. And point 13 that says when communications will not be received, that is not expressly said. It does not really flow properly. But again, I'm curious why. Why this is, while being discussed by others, why cannot it be imported? There is a word binding here that is very important. And the fourth issue, and my apologies for expressing it here, is the deadline, the 6 months. I am reading it here, and these 6 months will be provided to the interested party.
Now, who is the stakeholder? Was it the state or the one that submitted the communication, or both our stakeholders in order to see whether the state has met the obligations or not. So I'm not clear about this. Now, before handing over to you, number 34. After the 2 months deadline, after the inadmissibility, it says other parties may bring in a written request, members of the public, and also expert associations on the agreement. Please confirm. This is what we call the amigos curiae. Is that what this is about? And finally, I am missing an action mechanism for urgent needs. And this could involve the environmental defenders. Is there anything like a provisional measure, like the Human Rights Commission access when there's an imminent danger against a human rights defender? Or that is not contemplated? Thank you. I think that opening up a text like this in an open room with about 75 attorneys is a very brave thing to do. It is very proper of Escazú. It's common in Escazú to do this kind of thing. I have taken note of some of your recommendations because there were so many questions involved in your concerns. As to the free trade agreements, indeed, the experience with the North American Treaty is the one that has made most headway, and the Secretariat, together for Colombia, Peru, Mexico, and Panama, we have, by the way, talked to them on that modality. The report was concise. We have met on similar venues, but let us recall that we are not belligerent in nature. No. What we have often had to do is change the language. For example, talking about precautionary measures or provisional measures, and that is language coming from the inter-American system, by the way. This is binding. There is a judicial system in place that could be applied, but this does not fully agree with the nature of our committee. In talking about the fast mechanism for action requires diplomatic communications, speeding up the process, reducing the terms, the deadlines, and that is within reach of the process. So it will take some time for all of us to understand that the nature of this committee is of advising, following up. The measures that can be adopted will also depend on the state parties. Only yesterday, there was an agreement on focal points that we had not already ruled on. And there are many questions that have to do with translation. This all depends on resources available as well. We have said that there is openness in the committee. The expectation is that the committee be close to people, close to the territories. But much of this also depends on available financial resources. And I will now hand over Andres for the most difficult questions you posed. Thank you, Patricia, as always. There are many questions that have to do with the inadmissibility. Now, these modalities must come hand in hand with the rules. So we go to the rules. Item number 5, Roman 5, 5b, that says the committee will determine the admissible communications based on the following criteria. And it reads, if the case has been decided by other international procedure of binding natures, that is, the rules cannot overcome this ceiling that already exists by the rules. What we do is supplement elements amongst the admissible modalities. So what did the COP mean with other binding instruments? Well, this is it. Now let us take a look at other questions. Gustavo, you asked about what will the committee do in the adoption of conclusions or recommendations in preliminary matters. Will this take note on the observations? Let me think that I can't anticipate what will be done, but I can see the rules. And the rules say the preliminary conclusions will be negotiated by the stakeholder, and there's a 2-month deadline for that observation. After these 2 months, the committee will adopt decisions. That is, the committee will read, will bear them in mind, but it doesn't say what must be done. That means that each case will be seen separately. Now, the form says anonymous, but we have to go over this topic because the committee safeguards the confidentiality of what is requested. But the question we ask ourselves, how can we have an anonymous communication? Because if we want to safeguard the confidentiality of the person, that's the confidentiality, and that is set. But with an anonymous source, I don't know. I don't know what can be done there. Hearings, yes. Hearings to define what is not part of the inadmissibilities and whatever requires further analysis. As Patricia said, we can see if we can go to the territory. As I imagine this is where we will start. And there's another question. I will finish with something else and then I will hand over to Guillermo. The amicus curiae, that is the desire for information. We're not a curia, so it would be amicus comitae or something like that. But that is the idea. Indeed, we wish to receive a lot of information, but good information. In practice, we know how important this is, and we promise to commit to the following. We have been protesting in our courts that when we receive a comitae, we'll specifically mention that amicus if we're taking his idea, because as a litigant in Argentinian court, we have submitted thousands of amicus, and we are never ever mentioned of ever submitting this. So there is a recognition and appreciation of those who bring in important information to the courts. Felix or Guillermo? Gonzalo Aguilar. commented on this, on the hall rules. But the apparent restriction of those who make the requests, well, only the state parties and the public representatives do so. But there are other ways to ask for that, and the public, through its representatives, can also make these requests. As we heard here, we will have to see how this goes along in time. The countries are just starting to set up their national mechanisms. They're just starting with their national programs. So there is a certain time limit to monitor this. And in as much as possible, the modality rules also have the possibility of being amended or corrected when time shows that they are obstacles for the functioning of the committee. Thank you for your questions. Well, our colleagues have already answered clearly these questions. I wanted to add something from our standpoint as sub-working group on admissibility. There are things that we'll have to see along. Now, we have to have clear expectations on this stage of looking at communications. The fact that we are not an adversarial organ, that's not the idea, and this must be made clear. We are not judicial nor quasi-judicial, but that does not mean that there's not due process, as Andres well said. That does not mean that there are no contradicting possibilities, because that's part of the process. Nor does that mean that we will not follow the best practices that already exist internationally in terms of communication, or whatever we call it, because there are different names for this communication. We have been firm in Escazú in talking about communications, because we do not want to give the impression along the process that this is an adversarial process. No, nor is it judicial or quasi-judicial. And here, as we have the Kalstein pyramid in analyzing legal rules, here the same goes. We have Escazú that's on the top. Then we have the composition and functioning of the committee that has already been approved according to the competencies of Escazú, and naturally we have our working modalities. We are not a procedural code, by the way, and this must be made clear. The working modalities are not procedural codes, and they are written with a generic language. Perhaps it not as precise as it could be, because the international instruments must also use a generic language in order to allow for some space for maneuver. But I insist that that does not mean that the implementation of these instruments will not follow the best practices that we see internationally. And here I draw your attention, for example, on the rules of interpretation that is set by the Human Rights International Commission. Article 29 talks about this in that convention, and clearly it states that one must, in the rules, have the wider possible interpretation, not the strict interpretation, no, but the more flexible, wider interpretation. And also for having people at the center. And that means that text will be interpreted in with as much a level of guarantee as possible. So we would like to ask for your indulgence here, because as my colleague has already said, this will be submitted to an adaptation process. This process will be regularly adapted. We may have to change some of the working modalities, and this will be made public. Will be informed to the public and to the state to hear opinions.
And I also repeat, interested party is every state involved, interested party is the public engaged, and although we will not receive amicus, commissiae, or whatever, we will be able to receive opinions as set forth in the modalities of those who, mentioned there, would like to contribute an opinion and will be given credit. And so the procedure must be sufficiently flexible, because we are speaking of a situation and where case by case we need to examine it, and each one has its own specificities, and we will need to adapt to those specificities in each case. I also wanted to say, just to clarify, that I have here the website, and field 5 of the second page says, no, he corrects himself, it's not 5 but 4. If you wish to indicate protection of your identity and privacy. That is an anonymous. Anonymous, as our friends said, safeguarding the protection of a person on account of a particular risk that person, that yes, of course. And we need to make that distinction. And so I believe that with that, I conclude my reaction to the questions. And once again, thank you very much for your contributions. Thank you. I will now hand over to Carol Excel to see the following topics of our modalities of work.
As well, and thank you for your time to engage with the committee. Thank you for all the amazing questions you've asked. They help us clarify our work as well. And I've been asked to just briefly speak about 3 provisions of the modalities. So the specific measures for persons or groups in vulnerable situations. And if you have your text, that's 41 and 42. The rapid response mechanism, which is from 43 to 46. And then the provisions on amicable solutions, which is from 47 to 54. Just wanted to highlight a couple of things in these specific provisions that I think you could bear in mind in your thinking about understanding why we have these modalities. The first one on vulnerable groups, we want to point out that we understand, I think one of the questions arose was about how to address many people who are in poverty or have difficulty. The modalities recognize that specifically and require us to ensure that there's guidance and assistance provided to persons and groups in vulnerable situations in order to them to use the present working modalities with the view of adopting differentiated procedures that can allow them to actually be able to utilize them. So we are very much in discussions of what that could look like and what some of those vulnerabilities might mean in terms of being able to use these procedures. And we have a session later on this afternoon where an open session. We would love to have more thoughts from state parties and member of the public, how we could consider the implementation of that provision. But definitely it speaks specifically to the idea of translation or interpretation in those cases where the participation of vulnerable persons would otherwise be excluded if that is not considered. The next section on rapid response mechanism in relation to members of the public who have filed communications and they are in a situation of possible risk, attack, threat, or intimidation. Note here that it talks about a member of the public who has filed communications. So this provision is restricted to those who have done that. And then this rapid response mechanism flows from having filed the communication and made a notification to the committee that that is currently a situation of threat or attack that is being, that they exist for that communicant. And the modalities specifically talk about 2 mechanisms or 2 measures that can be done. One is priority processing of cases, and the second is adequate protection of members of the public through looking at protection mechanisms, both at the national and international level, and also undertaking an analysis of risk, and then being able to make observations, statements, or otherwise inform UN presiding states, focal points, and others about the risk that has been identified by the communicants. The provision, if you look at it, really requires the committee to understand the effectiveness of different mechanisms to be able to utilize or reach out to protection mechanisms. And in cases where there are no national protection mechanisms, to consider whether reaching out to international or other regional mechanisms will be required. But the provision relies on informing presiding officers, national focal points, and other designated members and parties to the Escazú Agreement as part of being able to invoke that rapid response mechanism. The committee will have to, including the rapporteur on rapid response, which is me, we will have to really understand and be able to map what is in existence for state parties to be able to implement this provision. So that will be a significant piece of work that I believe that we will have to do as a priority in ensuring implementation of any kind of rapid response. I want to note here too that the requirements say that the committee shall take into account the contextual analysis of the situation described by the author, and a personalized and comprehensive analysis shall be carried out in order to assess the alleged risk, noting that the committee should not make observations that could otherwise put a communicant in risk by their observations or recommendations. So it requires the committee to be able to assess the risk, not only to the communicant, but also to their immediate family, and assess and analyze that risk to make observations or recommendations. Last but not least, there is a provision on amicable solutions that has been included. And this is a provision that was included because we, in our discussions and observations, had talked to many international committees and non-judicial procedures who indicated that this type of provision has been very useful in practice to allow almost like a fast track of a resolution of a communication between both parties. The provision, as you can see, requires free and express consent from the parties, and also the committee also has to agree to be able to utilize this provision, which will allow amicable solutions to be received after determining facts and agreeing on solutions in order to ensure that the communication can be resolved in a matter that is more speedy, or that both parties feel that they're open to allow that flexibility of resolution in a reduced time frame and maybe more tailored response specifically to the communication. So the provision really tries to build in a sense of flexibility in the rules, almost a mediated type of solution. And then the committee still has, under these provisions, an opportunity to follow up on any amicable solution reached. So it doesn't take it out completely of the kind of space for dialogue and discussion, but allows for a new frame and type of solution that can be reached to be able to address the needs of both of the communicant and the state party. I think I'm going to stop there just to say that we also are really interested in hearing any thoughts you have, especially on the rapid response on that communication. I'm going to go to the last slide quickly because we don't have much time, but the rules also speak to this idea of being able to address cooperation and capacity building, so that committees' ability to cooperate with other types of bodies, both at the global or regional level, to seek synergies in our implementation, to make sure that we understand how other such committees work. We can also support capacity building. We recognize capacity building specifically on risk assessment will be really important for the committee. also capacity building of both state parties and members of the public in being able to use the communication mechanism and to ensure that there doesn't have to be a reliance on legal representation, that there is enough materials, support, so that they can use the mechanism without that being a requirement. And then there are also in the rules provisions on our moral standing, independence and impartiality, that talks about how to address issues of conflict of interest, how to deal with specific issues about how we observe guidelines and our individual responsibility when we represent the community versus where we can be represented just as ourselves, or our ability to attend matters and speak in our individual capacity and not as the committee. And also very briefly on how we amend the rules and the fact that we have to create, I think this was mentioned yesterday, a biannual work plan to indicate what activities we'll be doing and how we prioritize technical and financial support. I realize I've been going really fast, but we have 5 minutes and I wanted to preserve at least 5 minutes if there are any questions about those last provisions. Thank you very much.
Ah. No, ahí está. Ahí
There's the information, the address of the online platform, so that you may use it, check it out, and the screens will be left there throughout the day, and the address to communicate with the committee. Does anyone have a question or comment on this part in terms of the rapid response and modalities of work? Professor Michel Trou. Thank you, Chair. Well, I am president of the international NGO, International and Compared Environmental Law, and our organization is a member of the UCENO. And in the past, I was a member of two support committees for the ESPO Convention on cross-border impact studies, and the other one for the Convention of Barcelona on the Mediterranean Sea and coastal areas. Our concern is the legal implementation, of course, the accurate implementation of environmental law within the Escazú Agreement. And for me, it is necessary to make a significant distinction between the efficacy of the treaty, which is the result, the scientific and environmental outcome of implementing the Escazú Agreement, done with scientific indicators or economic indicators. It is the result of this environmental implementation. But to obtain this result or outcome, it is necessary to implement the legal side at national level of the Escazú Agreement. And the legal or judicial implementation that is similar to the objective and scientific side. But this judicial implementation, we do not know how to really measure the result of the implementation of the right, because unfortunately so far there are no judicial or legal indicators in order to complete the scientific indicators. And under the Escazú Agreement, the topic of implementation, of the efficacy of the proper implementation of environmental law is a very important concern. I believe it has been mentioned more than 27 times in the agreement, the term efficacy and implementation and so on. And that is why we recommend that it would be important and also an innovation, a practical and judicial.
El acuerdo de Escazú
That the Escazú agreement would integrate as a tool for legal implementation the legal indicators for implementation. For this, I believe the support committee could make a proposal by means of a specific committee or by means of the general observations mentioned in the document to develop this instrument in order to assist the states with a correct legal implementation. And the conversation on the Mediterranean Sea, as a result of that, it was decided to include legal indicators for the treaty and to help the implementation committee of the convention in order to get to know more specifically the legal specificities and challenges for implementation that the states must resolve. Therefore, our proposal is to integrate this tool into the support committee's work and the conference of the parties. Thank you. Thank you, Professor. I know very well the work you do on compliance of legal environmental law. And it is a good instrument to measure the efficacy of these norms. We thank you for your contribution. We are at present elaborating the work plan. Thank you. Does anyone else have any comments or questions? Andrea.
Buenos días a todos y todas. No, me presento, soy Andrea Cerami de las unidades de derecho.
Thank you. From the unit of human rights of the Supreme Court of Justice. I have a question on the quick of the mechanism for rapid response and whether this is the only way, or can the request be presented only due to a situation of risk to defenders? Thank you.
If you look at what the actual provision says, it does say a communication. It says in cases where a situation of possible risk, attack, threat, or intimidation. So possible risk. I think one of the issues that we ourselves will have to define is how to understand in a risk assessment what is a possible risk versus a threat versus attack or intimidation, to be able to bring this provision into its operations. And the communicant can provide information. It actually requires them to provide information to enable us to make that assessment. In 44, it says the author of the communication shall provide background information that gives reasonable grounds to believe that the risk referred to in the communication exists. The author shall report all material facts and events related to the risk, as well as any changes in the circumstances giving rise to the risk. So yes, my answer would be yes.
Thank you. Thank you regarding the rapid response mechanism, what if the urgent and immediate risk is to the natural environment, not the defender, him or herself? If there's need for an urgent intervention, advisory opinion of some kind. Thank you.
So the rapid response mechanism relates directly to environmental defenders. It was put in place to relate to the threat both to the communicant and also their immediate family by the fact that they've issued a communication and they now are in threat, or that they could possibly in threat. So it doesn't apply relating to a risk to the environment. It's a personal risk.
Una pregunta muy rápida, no sé si...
I have a quick question, not sure you've mentioned this. What is the difference between the actual position of Carol? For example, is it something that the rapid response mechanism should be addressed to her? Could you please further explain this? I wasn't here, I apologize for that. But what is your function, and why does that require a rapporteur within the committee? How have you divided the work so that you have this function, and is this being considered for other matters?
Yes, no, thank you for that question. When we put in place this working modality, we realized that both it requires an organization of an understanding of what is possible at the national level or what does not exist. If a communicant makes a communication and they are now under a condition of threat, the idea is that we would need to make a decision on prioritization of the case. We could make a decision on whether or not we can deal with both admissibility and the merits at the same time, and also how do we preserve their safety during the phase of communication. And so as the committee itself doesn't have an ability to engage directly in the country, it requires us to have some sort of a mapping of understanding the roles and responsibilities of UN agencies, national protection mechanisms, the role of state parties in providing those protections itself, or if there's nothing at the national level, how we can reach out to international mechanisms to provide safety so that we can safely hear the matter either in a hearing or on the papers. And so that is why the organization of work at its beginning stages, we're trying to understand what exists in each of the state parties. Are there provisions for protection or not? How effective are they? I think that sort of role will be important for the committee to be able to actually use access to these different bodies to ensure safety. I think Andres spoke many times about this idea of due process. We can't have a due process procedure if people are at risk, either through making a communication or previous to making a communication. So that is why we have to organize our work around this issue.
Bueno, me habías dicho.
You said that we only have interpreting until 12:45? Okay, thank you. So Aida and Marcelo? Thank you. We have two quick questions. I'd like to congratulate you for all the work you're doing and for creating these rapporteurs. And regarding the defenders, how are we going to articulate the rapid response mechanism? And in terms of specific measures for vulnerable persons and institutions, I would also like to know whether you've been able to establish differentiated procedures that will help us balance these asymmetries with vulnerable populations. Have you already talked about this? What would the criteria be that you will work with?
Thank you for that question. We recognize that the rules require us to have differentiated procedures, and one of the things that we want to discuss at the open dialogue this afternoon is this idea of what types of procedures do you think may be required at the national level to be able to reach out and enable vulnerable groups to be able to use the mechanism. We haven't in detail talked about what that role is. That is part of what we want to talk with both state parties and members of the public about, and try to understand what that could look like, especially if there are examples in certain state parties about what considerations may already be in place, or what modalities might we consider to enable this to happen. So it's a open question that we haven't yet defined, and I think very importantly we're looking to your input to help us define that. In relation to the rapid response mechanism, that too is an issue which I'm really interested to hear both from state parties and from members of the public about. There have been some assessments done in the region that have looked at rapid response mechanisms that exist in certain countries and the efficacy of them. There are other countries that there's never been an assessment, or that there are now states considering what they would do in terms of rapid response. I believe at the COP, St. Lucia mentioned, I think it was St. Lucia, or it may have been another country, mentioned that they're considering whether the Ministry of Health needs to be involved in a rapid response mechanism in their own country. And so, yes, this is a period of learning for us ourselves to understand what is happening at the national level and how this committee can engage with what exists currently, both at a national level, but also look at regional and international mechanisms that exist and try and understand how they interface in the state party countries as well, and whether or not there are mechanisms that we would need to be able to access at the regional and international level to be able to fulfill some of the obligations that are outlined in Part B, which talks about protection measures.
Gracias, Presidenta. Quería...
Thank you, Chair. I would like to specifically, I'd like to mention something on this matter. I apologize for not being here earlier. I would have liked to, but in this economy of resources and simultaneous activities, we had a session of the steering group for the agreement in the morning, early on, and I therefore then came to this group. I am extremely pleased and thankful because, well, with the fact that this meeting is being held, the support committee, as a subsidiary organ of the Conference of the Parties, had its sessions on the 22nd, and that day was Earth Day, and we approved the working modalities after a transparent process that was open, and after receiving contributions from different sectors and origins. It all came together into a document that looks to be practical, realistic at the origin and beginning of these conversations. And the Conference of the Parties members accompanied the decisions of the conference these 3 days. And today, once the conference concludes, there will be another session and the first day where according to the working rules, the committee is fully operational. Not just because it finally has been constituted and it has rules, but because the deadline has come in terms of the agreement and the rules for the Conference of the Parties to have concluded with a committee that is in full operation. And it does so by presenting the modalities with which it will function, and with a platform that allows it to enable, organize, and offer guarantees to the public as well as to the states on the communications that will be received and on the procedure that they will be treated with. I believe I speak on behalf of the entire room, and it is with great satisfaction that we have seen each of the steps taking place in time and form. We believe that that is the way for the agreement to be fulfilled and for all of us to have that frame of reference that is adequate to express ourselves and see how far we can go.
The idea is to participate without interrupting. I just wanted now to thank the committee as an organization and each one of you as members of the committee for this moment in which we are at now. Thank you very much, and thank you for giving me the opportunity to talk. Thank you, Chairman of the presiding officers. The committee has felt very comfortable and supported by the presiding officers in this process of creation of the working modalities and the functioning of our work. So thank you very much for being here to all state parties. I see a raised hand for Olympia and Maria Jose. And Francisca as well, I believe. Yes, we will hear these participations very short and close for lunch. Thank you. After hearing what the committee has presented, and that, of course, it seems very important for us. We that are not lawyers, we're very concerned. This work here is mentioning the strengthening of capabilities, but there will be a need, a work that is for the counterpart of those that will have to create the communications. Therefore, we need to think on how to transfer this or translate it to those of us that are not lawyers and that we have effective communication and the mechanism can really fulfill its task. Because we know how to reach you. Thank you very much.
Sí, muchas gracias.
Thank you. And of course, we want to again thank the voluntary work of all of you that are participants of this committee and for how fast you have been able to produce these rules and procedures. My first concern is to ask you, when do you believe we can start making use of these rules and procedures, and whether it will soon be any forms so that we standardize the presentation of communications and the urgent measures. And second of all, we know about your voluntary work, but along the same line that what Olympia was expressing, what has been taken into account in the dialogue that you have held with the authorities of the Conference of the Parties to foresee certain basic costs of functioning for all these activities, including all of the work that you will have to carry out, more than just your voluntary participation, but also what we are calling the legal community empowerment and the training for the defenders. I believe that we need to take into account that we have to have work for us with defenders, the forum, the state authorities. How do you see all these topics? Access to justice also has specific costs. Those people that will be presenting communications and urgent measures, will they be legally supported to access justice? Any voluntary activity is quite complicated at some point, and I think it is important to take into account certain line of work according to the suggestions that we're hearing. Thank you very much. My name is Juanita Arizo, Secretary of the Biodiversity Accidental Waters in Colombia and Deputy Focal Point of Ecological Justice of ECLAC. It is a fundamental point what Dr. Maria Jose Lubertino is expressing, and I would like to share with you that in the incidence process that we held during the 4 past years in defending the Escazú agreement and the different dialogues with the leaders of the economic sector, we were able to identify that there's a false paradigm of concepts that have been generated in avoiding the approval of the Escazú agreement. One of them is sentences coming from the economical sector in Colombia. I believe it is a fundamental element that we really break those fallacies, the ones that are affecting the process, and I believe the committee should have spaces that allow us for open and honest dialogues with those economic actors that, even though they're fundamental for the country and for the world, their economic richness or wealth should not be above the sovereignty of countries' laws or above United Nations. Therefore, I would like to respectfully ask to analyze how the Escazú agreement can really support us in guaranteeing not only what we love, which is the ecological dimension, but also the economic dimension of the society that has been really harmed by all these crimes that have been occurring against our environmental leaders, the ones that have been defending the law, constitution, justice, in those areas where unfortunately others have not been participating. So that is the question that I will present to the community. So how can we start consolidating goals and indicators within the explanation of the Escazú Agreement project and identifying and quantifying how to tackle the recovery and comprehensive legal rights of our leaders? We do need for another model of economic development that is fair and can be adapted to the new activities that we celebrated in the 65th session of Universal Rights, where we had the honor of working together with a global coalition and received the award of human rights in a healthy and free environment. So this is the question. Thank you very much. Thank you and all that have been with us in this session here this morning. We do have a tremendous challenge ahead of us in terms of the backing of the public that would like to use this platform. Maria Jose, maybe you were not here earlier when we explained that everything will be aligned, or everything is already aligned, where the platform is open, that there are screens outside of the room so we can see how all this is working. But we also insisted that communication is a process. a process that will take some time, and it has the different stages that guarantee due process for the involved parties, and there has to be a stage of preparedness and backing for the public that would like to make use of that possibility. The Escazú agreement is providing, not only providing us with the possibility of the non-compliance due to these non-compliance, and rather create reports of consultations at systematical level. There are many functions that the Escazú agreement and rules of procedure are offering to the members of the committee. And in the area of resources that we do feel very comfortable with, and we're aware of this, we are forcing ourselves to go through these planning processes in defining work plans for 2 years that where we will identify the resources for the functioning of the committee and to satisfy the needs of being close to territories and people where we need resources. There is the will of all of us participating in the committee, and we hope to develop the strengthening of capabilities and the search of resources where we will be able to fulfill with or comply with our functions. I would now like to invite you for a lunch break, and we want to invite you to reconvene at 2:30 in this specific topic of the work plan for the committee. Thank you very much.
Muchas gracias, Presidenta.
Thank you, Chair Lady. Thank you to all members of the committee for their work, to participants. And I would like to briefly invite you to an event that will be held in ILO, which is a conversation on the implementation of cooperation for the Escazú Agreement. You can find it through the Southern Access, Dag Hammarskjöld, right in the corner, and the workshop will be held there. You are all welcome, and thank you on behalf of the Secretariat of Escazú.
Y finalmente,
And also, we want to remind you to please take all your belongings. Nothing can be left in the room.
Bueno, disculpen.
Apologies for the delay, but we were at the parallel events that Mexico had for cooperation, and they were also delayed. But here we are again, and thank you very much for being here. Is interpretation working? Can you hear it? Yes. After reviewing the virtual platform where we have the communications procedure and to review the working modalities document, I was mentioning that one of the articles of the working modalities established that the committee should create a biennial work plan from here to the next COP 2026. There are some questions that we have and we would like to share with you. And what we're proposing, as there is a parallel event here at 4, what we have is a little less than an hour for some small working groups with 2 questions each. Work group number 1 will be composed of Carol. Group number 2 will be with Andres. And group number 3 will be myself in that group. We will have it in the screen in English and in Spanish. And maybe I can offer the floor to Carol so she can explain the questions.
Thank you, everyone. So the idea is that we will split into 3 groups. Group number 1 is going to speak about the organization of work of the committee and rapporteurs. So specifically, the rapporteur and rapid response mechanism, and also talking about the organization of our work to support vulnerable groups. And the 2 questions we've come up with is 1, the committee has established a rapporteur and rapid response. Your input is crucial in determining the priorities of the rapporteur. What do you think should be the key areas of focus for the implementation of Section 43 on rapid response mechanisms, especially considering the status of the development of a protection mechanism in your own country for environmental human rights defenders? That's question number 1. And we will have these on the screen so you don't have to write these down. And the second question is number 2, the working modalities strongly emphasize a commitment to supporting vulnerable groups. How would you propose implementing an area of work considering your own country's circumstances? Group number 2, that focuses on reports and observations. The first question we have for discussion is the committee is mandated to complete a systemic report for presentation at COP4. We are open to your suggestions on what systemic issues should be considered for this report. And the second question for that group to discuss, the committee may decide to prepare and adopt general comments on specific subjects related to particular aspects of the agreement with a view to supporting the parties in fulfilling their obligations under the agreement. Are there any specific topics, either that came up with the COP or otherwise, that state parties, members of the public would find helpful for general comments? So that's the second question for group number 2. Group number 3 on capacity building and dialogues. The committee has prepared a draft work plan that includes capacity building as an important aspect of its work. Are there any thoughts on the focus for capacity building sessions or measures and how they can be best be scheduled to support state parties, focal points, and the public? The second question on the capacity building is the committee may hold up to 4 open dialogues a year with state parties, including a visit to a country with consent. Are there states that are interested in the dialogue? How can the committee ensure any open dialogue is effective within a state with significant participation of the public? So those are our questions for the 3 groups.
Muchas gracias.
Thank you, Carol. For those that want to work in group number 1 about rapporteurs and organization of the work committee, where will you be staying? For those of you that want to work on reports, observations, and comments, where? With Andres? And group 3. Capacity building and dialogue. We will be doing it here in this corner. If we have time enough, it would be wonderful to stop at 35 after 3 and be able to hear the comments of the group and close at 4. Conclude the session at 4.
They're very valuable comments. Group number 2, you have the floor. We are number 2, very well. So we have a rapporteur by me, but if you want to add things that you may be forgetting, just let us know. We have 3 groups of recommendations or thematic matters that we would like to know or see in thematic reports by the committee. So the first group has to do with interpretation, general interpretation of the agreement. It would be wonderful to have an interpretation in regards to Escazú as a treaty for human rights and what that means for interpretation under the general principles of the law, international law specifically. Second, we would work on Article 7.2. We would like to hear from the committee an interpretation on what the definitions and impacts, significant impacts are for the article, and each party will guarantee mechanisms for participation for the public, the decision-making process, revisions relative to the project and other environmental authorizations that could have a significant impact on the environment, including when they could affect the health. And these are somehow related with the agreement on this in this first set, and we would then go with number 5E with the rules of the, which is binding at an international level. It has to do with admissibility of the cases. So should we find it earlier, or whether it's due to another internationally binding instrument, then it would be declared admissible.
Vale la pena. So it is important to establish what the binding international procedure is. The second issue is we have talked about the obstacles and barriers in terms of access to the rights to access. First, the management, bureaucratic access to information, the delay in receiving information, and second, a very common practice in our countries is the judicial aspects of the requests of information. We always have to go to judges to receive information. And right to access to participation, the need of countries have a legislation that will enforce and will expand the citizens' participation more than just the previous consultation. And finally, in terms of justice, we are concerned with the limitations in the legitimization that is proactive, anything that is related to free activities, and of course the delay in the process, and likewise the lack of the ruling or something that is different that comes from the judicial decision-making process. And the third group of observations that is related to defenders, we believe there's a systematic problem in the region that is related to the criminalization of defenders, which is the improper use of the legal system against defenders, not only is from civil rights, management, fines, and others. And I simply believe we can close by saying that we have a very important challenge as a region in matters of guaranteeing rights of access and a safe area for defenders in energy transition. Energy transition is placing on the table pressure and urgency messages. We have to be able to go through these areas and which are the consequences and results and effects it has on the rights to access in the public space and democratic actions in the environmental justice principle. Thank you very much, Group 2, for that very speedy participation that left us all saying like, okay. And now another speedy participation of Group 3, capacity strengthening and dialogue. Hello and good afternoon. I am bringing here my notes from Group 3. Our group was the training in dialogues, and we talked about continuing and deepening in the basic training of what is Escazú, the mechanisms, the equipment and others. And we were saying that we should continue in all of the levels of CSIC, including the learning material in different languages and related to other issues such as age and others. It is very important to have constant training for the different states because we know that there is high mobility in workers, even in governments in our region. We know it is very important to train the local governments and communities in taking Escazú to the territories, which will help and have more permeability in these areas. We talked about training that is focalized by groups in content that is adapted for each audience. The example of the legal clinics was used. And there are many other professional groups that are providing to these areas in environmental discussions and that also need to be right in the midst of the training processes. We talked about creating partnerships with local partners in what is the Escazú agreement for public consultation to avoid bureaucracy, perceive this as social participation in the process is just a mere activity, but it is something that can really be participating and mean a significant change for many locations. We talked about being careful to adapt the mechanism, these training, to the different cosmovisions of the original people and traditional groups. We talked about the dialogues of the states based on the implementation plans, taking into consideration the lack of connectivity and their sacrifices. We even established a map and we found the opportunity to link all these possibilities with local laws, such as the in Argentina or Brazil, that can also help the committee to have more parity. We talked about specifically training children and legal trainers for the states and NGOs. These are our recommendations, and thank you very much. Thank you very much on behalf of the committee. We really could not thank you as much for this supply. We will be changing the world. We will be doing it very soon. And thank you very much for this wonderful session of supplies. And now we will try to start talking about mainstreaming and the gender issues. Thank you very much.